I'm here today with Lisa Jemmeson from Jemmeson Fisher Solicitors and Accountants. Hello Lisa, how are you?
Hello.
You're an interesting story. You're a solicitor and a licensed real estate agent, business agent, strata agent.
Yes.
Wow, so you have lots of information that you should be able to share with us, and we're going to talk about property management today, and we're going to talk about how do you prepare for a tribunal hearing.
Okay, first of all, when we talk about the tribunal, what we're talking about is NCAT, which is the New South Wales Civil and Administrative Tribunal. It commenced from 1st of January 2014. What it did was combine 22 tribunals and put it all into one place. It's now 4 divisions. As a property manager, you'll be off to the Consumer and Commercial Division. NCAT here is roughly 80,000 matters per year.
80,000
80,000. In the tenancy division, you've got 31,500 applications that are lodged. So they're hearing quite a lot of matters each year. In the tenancy division, some rough figures, basically 75% of the applications are landlord applications. You've got 24% that are lodged by tenants and 1% that are lodged by other people, and they can be prospective tenants. When we look at the 75% that are lodged by landlords, 42% of those applications are for rent default and for possession. You have an additional 17% that are for breaches and for possession, and then 14% for bond matters. So they're your big 3. So they're the key areas that we'll probably look at today in relation to preparing for a hearing centre around those issues. So probably a good place to start is what sort of documentation are you going to need? So the first thing is going to be your managing agency agreement, and that's an important document because that provides the authority for you to appear at the tribunal. So it's this contract between you and your landlord, and it delegates certain responsibilities to you, and you have those responsibilities that arise through the agency contract itself, and then also through your fiduciary obligations, and then further through the Property Stock and Business Agents Act and the regulations in relation to what should be in your agency agreement, and also codes of conduct in relation to property managers as well. So you need to make sure that you have that as your authority to appear. Second thing that you want to make sure you have is a copy of your lease. Now, the lease document itself is a prescribed document in the regulations, and it takes a standard form pursuant to Section 15 of the Tenancy Act. Next thing is your condition report, so the ingoing condition report. Again, this is a prescribed document which is in Schedule 2 of the regulations. You'd want to make sure you have a copy of that. The next thing that you want to take along to the tribunal is going to be the ledger, which is going to show what payments have been made. It's a requirement under Section 37 that the landlord through the agent keep a copy of all the rent payments made.
What might the member look for in that ledger, Lisa?
Well, 2 things. First of all, if the application is pursuant to a termination for rental arrears, they may be looking to see that at the time the termination notice was received by the tenant, they were indeed 14 days in arrears. The other thing relates to the allocation of money. So for example, if tenants are paying money into your trust account electronically, they'd want to see that you're allocating their rent money to rent and not to, for example, water usage charges or default fees for cheques that may have been dishonoured or debt payments that have been dishonoured. So they're looking for that to ensure that the tenants are not placed in an arrears of rental situation due to the agent's allocation of funds. So that's important. Next thing is a termination notice, and a prudent property manager will just go over and verify and check that this is being completed correctly. Now, assuming that most agents are going to use standardised forms either produced by EAC or the REI, some agents do their own termination notices, but one should have a look and ensure that all the particulars are correct, the correct notice periods have been provided, and the service details are correct on the termination notice. And there are various reasons why a landlord may issue a termination notice. It may be for rent default, as we discussed a little bit earlier. It could be for a breach of a lease. It could be to bring a fixed term tenancy to an end. It could be to bring a periodic tenancy to an end. For a sale of premises, so if you've just sold it, you've been out and auctioned the property and the property's been sold. So there may be different reasons why a termination notice has been issued. Now, having said that, not every breach of the lease will automatically terminate a tenancy, and a property manager should keep that in mind when litigating on a termination notice. There is an exhaustive list that a tribunal member may look at, so they will look at the nature of the actual breach. So it might be something quite minor, any previous breaches, any steps taken to remedy those breaches, and the previous history of the tenancy as well. When we look to bringing a tenancy to an end, maybe on a no grounds notice, the common law is also quite instructive for tribunal members as to the considerations that they should turn their mind to in relation to bringing a tenancy to an end. And I'll just run you through some of those quick considerations for property managers so that they can have those in their mind. How long the tenants have lived in the particular property, the ages of the tenant, the health considerations of the tenant can play in, how long the tenants have lived in the area, the employment of the tenant, any renovations that the tenants have undertaken on the property. Friends and social contacts of the tenants in the local area is a consideration.
Really?
Yes. Whether or not the rent is paid up, any breaches by the tenants, so breaches of the tenancy agreement, complaints from neighbours can be a consideration, any concessions offered by the tenant and the conditions. So they may have said, look, I'll move out earlier, but you've got to pay my removalist costs, or I want 3 weeks free rent, so they'll consider that as well. And they're coming from the common law, and they're the types of things that a tribunal member will consider in relation to bringing these tenancies to an end when they're not specifically for a breach of the tenancy. Now, a question that we often get asked is in relation to defects in the termination notice. So it has got through and you've got to the tribunal and there is a problem. The members do have a power to remedy a defect either in the termination notice or the service of the notice. And with the new Tenancy Act that is not so new these days, there are different methods of service, one of which is by personally delivering the termination notice to the letterbox, for example. So if there was indeed a defect in that notice, then the tribunal does have the power to remedy that defect. But that is at their discretion, of course, and a property manager shouldn't rely on that particularly happening. There are situations where you can go straight to NCAT, so you don't need to actually issue a notice of termination. And just quickly, I'll run through the main areas. And the first one is where there is serious damage to the property, and that's been caused either by the tenant or by an occupant of the property. So serious damage or threats to the landlord's agent, or a contractor of the landlord. And the other area, and this particular area, there hasn't been a lot of litigation through NCAT in this area or the previous CTTT, and that's in relation to hardship to the landlord, and that's done under Section 93. So a termination notice wouldn't have to be issued and you could go straight in for a determination at NCAT. Next thing you'd want to make sure you have a copy of, if you're at the tribunal for non-payment of rent, would be a copy of the payment plan. So if property manager and the tenant have come to an arrangement that arrears may be paid off and there has been a breach of that arrangement, then you want to have a copy of that to show the member. Any rent increase letters, if you have a look at the tribunal hearing notes form, you'll note that they confine it to the last 12 months, but it's a good idea to have all your rent increase letters to the tenant in the file. Any correspondence, so a lot of software providers will actually allow for a property manager to log SMS correspondence to the tenants, emails, letters that are sent. A lot of it's all done through the trust accounting software, and there'll be a chronological date order of every piece of correspondence, and that can assist in relation to chasing a tenant up and showing what the agent or property manager has done in relation to contacting the tenants. Now, if we move over to a property manager that is there over a bond matter, bond dispute, a copy of the outgoing condition report is imperative and obviously needs to be completed. One thing I'd just like to say about that particular document that I think a lot of property managers are not aware of, there is a requirement to reasonably attempt to have the tenant present at that vacating inspection with the agent.
A lot of agents don't do that.
A lot of agents don't do it. And the problem is that the tribunal looks at that form that if both parties are there, that it's a contemporaneous record of the condition of the property on that day. And so if you've got one party that completes it, the property manager, and the tenant is at the tribunal hearing and says, I would have loved to have been there, but I wasn't given the opportunity, then the member will likely discount the evidentiary weight given to that document. So I think property managers have to be very aware that they have to do more than wait for the tenant to ask to come along, but actually actively try and have them there at the vacating inspection. Also, it may indeed solve the issues that you're at the tribunal trying to resolve if the tenants are there with them. So that's important to note. Next thing, any photos. Photos that go up in tribunal matters need to show which room it relates to. So I think a common bugbear of members is that they get various photos of walls. It doesn't mention which wall, what the photo is actually taken of, so they can be quite blurry. These days a lot of photos are done through the office on colour printers and they're not necessarily clear. Property managers need to make sure that it's a photo of what they're trying to show and to discharge their evidentiary burden in relation to a particular item. Moving on to invoices and quotes for repair work, it's very important that everything is itemised and you get your tradespeople used to writing invoices that itemises each item on there and as it relates to the bond claim, and mention possibly whether this is a tenant issue or a landlord issue as well. Handing up a bill for $500 for general repairs, a member will look at it and won't be able to decipher or apportion money to what the tenant is responsible for and further what the landlord is responsible for.
Should we be talking about depreciation as well?
Absolutely, and I'm glad that you've mentioned that because this is really important in relation to anything that you're claiming, for example, an item that a landlord would ordinarily depreciate through their taxation returns. There's a tax ruling, 2014 tax ruling, which a property manager can go in and download, and all these items such as lino, vinyl, carpet, has a lifespan. So if we take carpet for example, if new carpet was laid in a bedroom for $800 and it's been down for 2 years and the tenants have been ironing on the carpet, which is my particular favourite because I'm yet to meet anyone that irons on the carpet, but and there's burn marks all over the carpet and the property manager wishes to, or the landlord instructs them to replace the carpet, then that item has to be depreciated. So if the tenant's been in there for 2 years since the carpet's been laid, and the lifespan of that carpet's 10 years, you're going to have to knock $160 off that. So make sure that those calculations are done and handed up to the member so that he doesn't have to do it, which is quite important. Water usage, if that's often forms part of a bond claim, make sure that that's correct in how it's calculated, how many kilolitres it's for, what the rate is. All those calculations are there for the member to review. And one of the final things is in relation to expert reports, and we certainly don't mean to scare people or property managers off by using this term expert reports, but I think it'd be easy to say that if I went out and gave a report on a building issue, I would have a lay opinion, whereas a builder, a licensed builder, can provide a report using his expertise through study, training, or his expertise as to what the problem is. And there's a set way that a tradesperson can prepare this report, and in the documentations I believe you're supplying property managers with a copy of a sample expert report so they can go through and have a look and see how this should be set out to further assist them with their claim. Now, just some other things in relation to preparing for NCAT or your tribunal hearing. At first instance, the matter will be sent to mediation, and so there is an opportunity for both parties to exchange documentation and go through their sides of the claim. It may be the first opportunity that you've had to explain to the tenant what the claim relates to and why things are being claimed. It's a good opportunity, and I think for matters to be sorted out at first instance, and I think property managers need to have a very open view in relation to that and be prepared to negotiate. They need to have a conversation with their landlord before they go in as to what they can negotiate on. Often property managers turn up and will say, I don't have instructions on that, I don't have the authority to drop that particular part of the claim. Get those instructions, know exactly what you absolutely must pursue and what is maybe less important.
So what you're saying, you can save a lot of time at conciliation if you're prepared for it.
That's right. The other thing I suppose is not be so combative in mediation as well. Generally there will be a mediator that is often another member that will hear the matter, and I think combative is the word to describe some agents that go in. I think it's about having a conversation and an open dialogue, and at the very least understanding your opponent's side of their case and any maybe potential weaknesses that they may have in their case. And the mediators are quite good. I think they'll point out to both sides if there are particular weaknesses in either party's case. If the matter can't be resolved at mediation, then it will go before a member. If it has to be laid down to hearing, it generally won't be heard on that day. There may be directions made by the member for the parties to exchange documentation and also to supply a copy to the tribunal. So you'll have a directions hearing where that is made, and then you'll come back for a formal hearing set. So you generally, out of the main general list, you might be put into the afternoon session. They'll allocate time for the actual hearing. Then it comes down to your evidence and how well it's actually been prepared. Your burden is on the balance of probabilities. Okay, so just tipping that scale, and I think the O.J. Simpson case is a good way for people to understand the difference between beyond reasonable doubt and the balance of probabilities. So he wasn't convicted at a criminal level, which was beyond reasonable doubt, but lost his civil trial in relation to his wife when the family sued because he couldn't discharge. It was much easier for the other side to prove on the balance of probabilities, and that's where agents need to be. You're on the balance of probabilities. So have all your documentation prepared, be ready. When you go before a member, when you hand documents up to a member, it should be what you have supplied the other side. There's no smoking gun. Every document has to be seen by the tenant. You can't slip something in. I think it's good practice not to put it in folders with plastic sheets, so the members have to start pulling everything out. I think ring-bound folders or whatnot that's all tabbed so that they can find things nice and easy. And generally the member will ask both sides of the story. When the other side is speaking, don't interrupt. It's a big no-no, and you see it all the time in tribunals, property managers that are quite anxious and blurt in and try and talk over the tenants. You'll get your opportunity to speak. Once you have given your submissions to the member, they may ask you questions, and the other key important thing is answer what's been asked, because members get very frustrated. We said earlier, 31,500 tenancy matters before the tribunal every 12 months. It's a sausage factory. They're seeing hundreds of these. They'll ask you a question, answer what they want. Don't tell them about something else, because it just frustrates them. And I think that's just a professional courtesy. And at the end of the day, have your landlord prepared that if you do go to a final hearing, then often the member will try and strike a balance. So there may be some concessions that the landlord will have to live with, flowing from the outcome of that particular hearing.
So it may be best to have those concessions up front and not have to worry about going to the tribunal.
Very early on, yes indeed.
Lisa, can I thank you very much. I think that was excellent, a great deal of information in there, and I hope that helps all our property managers.
Indeed.